Hello, hello, hello. Good afternoon and welcome to our live podcast. This is Dr. Olu Asekun here. This is another beautiful Wednesday. This podcast is every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. So we are here again. Please remember to call your friends, call your family members, um, call your colleagues at work. It is time for another podcast. And I believe today's topic is, I think you still have the wrong topic there. It's talking about VAWA. That's not what we are discussing today, please. Okay. Today's topic is what to do if your petitioner is no longer interested or able to pursue the case. That is the topic we are discussing today. Is this live? It's still not showing the topic.
No, the one on my phone isn't live.
Can you please update the topic?
It's there. It is. It's up there.
Okay. Today's topic, what do you do if your petitioner is no longer available? When we say petitioner, it could be employment-based, it could also be family-based. So, if you have a pending petition and then suddenly your petitioner is not available, what are your options? The reason we are discussing this topic today is because we get lots and lots of questions relating to that, and we've seen situations where people don't know what to do, and in the process, they lost a golden opportunity to obtain green card. Actually, depending on your peculiar situation, I've always stated it on this platform that immigration law is not a one-cap-fits-all. Every situation is unique. Every situation is different. But we can also discuss what most situations are. So if you have an employer, let's say you have a pending employment-based petition, and maybe after some time, the employer is no longer available. So what are your options? The first thing you do, it depends on the type of petition that is pending, and it also depends on what stage you are in the process. If this is an employment-based petition and the I-140 has been approved and visa is current and you have a pending I-485, and then your employer decides, or your employer is no longer available, or maybe they terminated your employment, or maybe something changed and they are no longer willing to continue, what are your options? Now, if your petition, especially your I-485, if you have I-140 petition that has been approved, you can actually transfer it to a new employer. If your petition is still pending, but you file it concurrently, and your application for adjustment of status, I-485, has been pending for more than 180 days, the law actually allows you to change your employer. So in which case, you can change your employer even if the original petitioner is not willing to continue. If your I-485 has been pending for 180 days or more, you can change your employer without it affecting your ability to get your green card. Now, if it's a family-based petition, if your petitioner, let's say it's your spouse that filed the petition on your behalf, and then the petition is still pending, whether the I-130 is still pending or is been approved, it does not really matter, because for as long as the petitioner decide to withdraw, whether the I-130 is pending or is being approved, if the petitioner writes a letter to immigration that they want to withdraw their petition, that will be the end of the petition. That will be the end of the petition, because at that stage, there will be no petitioner. However, in some cases, that petition may still be salvaged. The petition may still be salvaged, but again, it depends on the peculiar situation of the applicant. Now, let's say the petitioner died. You have the I-130 pending, you have the I-485 pending, and then suddenly the petitioner died. So what do? Does it mean that you lost the opportunity? No. Can you please help me get to the question where I can see when people send in questions, please? Okay. So what do if the petitioner died? Now, if this is an immediate family petition, when I say immediate family petition, it means that the spouse of a U.S. citizen is the petitioner. So if this is an immediate family petition, that petition, the I-130 petition, can be converted into I-360. That I-130 petition that is pending at the time of the petitioner's death can be converted to I-360. Now, I-360 is a self-petition, but this time is going to be what we call widower petition, widow or widower petition, because the U.S. citizen spouse, who is the petitioner, is the one that died. So that petition will be converted from I-130 to I-360, widower petition. The only thing, the evidence of commingling of assets before the petitioner's death, all the evidence of what they did from the day of the marriage, even up to the time of the burial of the petitioner, all of these things will be relevant. The petition will be converted to a widower petition. So in order to convert it to a widower petition, all that the applicant needs to do is to write a letter to immigration and attach a copy of the death certificate of the petitioner and write a letter requesting the petition to be converted to a widow or widower petition. That is all that the petitioner is required to do, and that petition will remain active and will be adjudicated. And if approved, the applicant will be able to get his or her green card. Now, what if the petitioner is a child, or is a parent, or is a sibling, and then the petitioner died? Again, depending on the peculiar circumstances, in some cases, the petition may be salvaged. Now, this procedure is different. This cannot be a widow because you are not a spouse. This cannot be a widower. This can only be a substituted petition. So you have to request USCIS to substitute the petition with equally living petitioner. What that means is that, let's say a U.S. citizen father files a petition for their maybe unmarried children over 21, or even married children, or siblings. And then that petition has been pending for a long time. Now, the petitioner died. Is that the end of the petition? No, that is not the end of the petition. Now, even though the petitioner in this case is the father, if the mother of the applicant is also a U.S. citizen, the applicant can request the mother, who is a U.S. citizen, to be substituted for the petitioner that died. So now, upon the substitution, the the process will continue. So it is not required that the mother will file a fresh petition. No. The mother only need to apply to be substituted for the dead father. So the petition remains alive. But like I said, every case is different. So this is not a one-cap-fit-all, and that is why I keep repeating it, that each case is adjudicated on its own merit. I see that a lot of questions have been, okay. Please send in your question as we proceed, so that we have enough time to answer the questions. Now, what I'm explaining in essence is that the fact that your US citizen petitioner died does not mean the end of the petition. Now, that is the case of death. Now, there are other cases. What if the petitioner is alive? What if the petitioner decides not to pursue the petition? Are there any circumstances under which the petition can be salvaged? Yes. In some cases, the petition may be salvaged in some cases, and in some cases, the petition may not be salvaged. Now, let me give an example. I know someone whose spouse filed I-130 petition for, and that petition was approved. Now, that person was in removal proceedings, and because he was in removal proceedings, we were unable to file I-485 with USCIS, so we have to adjust in court. So we filed the I-485, but before the adjustment hearing, the US citizen spouse filed for divorce. And of course, before the hearing date, they were divorced. The question is, what do you do in such situation? Again, it depends on the circumstances of the particular case. Every case is different. In some cases, you may be able to salvage the petition. In some cases, you may not be able to salvage the petition. So I'm not going to give a general answer to say that, you'll be able to salvage the petition. No, it depends on the particular situation. In this case, in this example that I gave you, what we did was to apply for special rule cancellation of removal for that client. Based on that client peculiarity, yes, that worked. But that may not work for another person. And that is why it is important to understand that this is a topic that is unique to each individual, and it is based on a case-by-case basis. It is not a one rule for everybody. Okay, let me see. The first one is just a greeting. Okay, good afternoon, Dr. Asekun. Okay, good afternoon, ma. Thank you for joining. The first question here, that one is a greeting too. Okay, good afternoon, everyone. The first question, I see part one. Am I expecting the part two? Okay. Do you want me to wait for the part two? Okay, the first question, part one, is a two-part question. My husband and I were traditionally married. He applied for K1, K2 visa for my son and myself, claiming it would be faster. I arrived and he was emotionally and physically abusive to me. Part two, he proposed an arrangement marriage and flaunted his new relationship. we did not get legally married in the US before 90 days. I was forced to move to US. I have nowhere to go. What do I? This is not related to today's topic. What we are discussing today is what to do if the petitioner is no longer available. Is it relevant? Okay, but I think this one should have come under K1 when we were discussing K1. But anyway, I will go ahead and answer it. But still, there are some things that are not clear here. It says that they were traditionally married, but traditionally married before K1 or before or after? Because if you are married, and I also don't know which country this is from, if you are married, either traditionally or legal or under English law, a marriage is a marriage. If you are married, then you will not be eligible for K1. So you will not be eligible for K1. So if you have K1, so does it mean that you obtained the K1 fraudulently? You didn't disclose the marriage? I mean, there are so many things from this question. If you disclose the marriage, then you are not entitled to K1. Now, if you did not disclose the marriage and you obtain K1, then that means the K1 was obtained unlawfully. But now, to the question, what do you do? Here is what you do. If you have evidence that when you came, you live with this person, you stayed together, and even though you didn't get married within the 90 days as the law required, but if you have evidence that this inability to get married is it was a consequence of the abuse and all of that. When we were discussing K1, I've explained that if somebody entered the United States with a K1, you cannot marry anyone else. You cannot get green card in the US through any other person. So getting green card through another person is not even an option. But in this case, even though you have a K1, even though you didn't get married within the 90 days, you can actually use the previous traditional marriage and then apply for VAWA if you have the evidence of abuse. For VAWA, the fact that you didn't get married within the 90 days will not matter. You can still get VAWA approved. What is important is to have the evidence of abuse, to have the evidence that you are abused. And of course, evidence that you understand from this question, it says the person referred to a son. Was this son born between the two of them? Okay, yeah. Since the son was born between two of them, that is another evidence of the relationship. That is another evidence of the validity of the relationship. And because they lived together and because they had a traditional marriage, the fact that they didn't get married in the US within 90 days will not stop this person from getting VAWA approved. So this person can still pursue the green card through VAWA process. And it depends on whether this person is here in the US. If he's here in the US, he can apply for VAWA and apply for adjustment of status. But if he has returned to her base, then she can file the VAWA and upon approval, go through consular processing. But the long and short of it is that this person can still get the green card, irrespective of not getting married to the husband within the 90 days required by law. The next question. My mother, a US citizen, petitioned for my siblings. A visa became available for them after my mother, the petitioner, passed away. Can my siblings continue with the immigration process? Well, this person didn't talk about the father's status because, like I said, the challenge you are going to have with siblings continuing is that the visa category is going to be different And substitution may not be possible where the visa categories are not the same. Because when a US citizen petition for adult children, whether married or not married, the visa category is different from when a US citizen petition for siblings, because siblings is the bottom of the ladder in the visa category stage. You have US citizen petitioning for immediate family. That one is not affected by visa bulletin. Whether visa is current or not current is immaterial. Visa is always current for that category. Then you have F1, that is US citizen petitioning for unmarried children over 21. Then you have F2. F2, we have F2A and F2B. F2A, that is a permanent resident petitioning for spouses and children under 21. Now, we have F2B, that is permanent resident petitioning for children who are over 21 but unmarried. Now, we have F3, that is a US citizen petitioning for married children. And then we have F4, which is US citizen petitioning for siblings, adult US citizen petitioning for siblings. So, if you are going to substitute, it has to be in the same category. So, if you are going to substitute, if visa is current for the US citizen petitioning for your siblings, for you to take over, visa must be current. And usually, siblings and US citizen children, they are not always on equal path. So, US citizen petitioning for children, whether married or unmarried, it take precedent over US citizen petitioning for siblings. Siblings is the last one in the ladder. So it may be difficult to substitute because they are not in the same category. The next question. I came in on a fiancé visa, but we have not married. I came in 30 days ago, but she does not want to marry me anymore. I found an employer that is willing to petition for me. Is this possible? Well, the employer can file the petition for you, but you will still have to go back home. You cannot adjust in the US. You cannot. So the employer filed the petition. If the petition is approved, you go through consular processing and you go back home. And let me warn you, thank God you just came in 30 days ago, which means you are probably still in legal status. If you are planning to go through the route of employer, don't stay here until you are out of status, because the moment you are out of status, even when you go out, it will be difficult to come back in, because your employer may not be able to apply for a waiver of unlawful presence. So that is a family kind of waiver. It is not available for employers. So it is better for you if you go back home before you are out of status and process your employer petition from home. But to adjust in the US, it is not possible. You cannot adjust except the K1 petitioner follow up with the petition. The evidence of abuse and then apply for VAWA. You are eligible for VAWA. It doesn't matter whether you have been married, whether you have filed a petition or not. You can apply for VAWA, and if it is approved, you can adjust. But you cannot marry somebody else. You cannot adjust through any other person since you came in as a K1 entrant. The next question. I came to the US when I was promised a job as a nanny. However, the family has decided they no longer want me to nanny their kids. Is it possible to find another family to nanny for? Well, this is not even a question that is relevant to our topic today, but at the same time, the answer is no. I will direct this person to our podcast on how to get legal status as a nanny. So we have a podcast where we have discussed the issue of nanny extensively. So you can go back to watch that podcast. But the simple question is no, because the way the requirements are, that is not something that you can transfer from one person to another. And you have to be maintaining legal status. The next question: I had my green card process pending. Then my spouse passed away. Can I continue with it if I'm able to prove good faith marriage? Oh, yes. All you need to do is to write a letter to immigration and ask them to convert the pending petition that was filed on your behalf, to convert it to a widower petition. So you attach a copy of the petitioner's death certificate to show that he has passed, and then ask them to convert it. So for as long as your marriage was in good faith and you lived together as husband and wife before he passed, this petition will still be approved. Yes, you can continue with the process. The next question: I was just scheduled for an interview and literally cannot find my wife. She has a bad drug habit. Do I still attend the interview? Do I try to reschedule? I have just under a week. To be honest with you, this question to me raises a lot of red flag. I mean, to even begin to answer the question itself raises a lot of red flag. If you are married and you have a pending application, and then you are telling me you cannot find your spouse, that raised a legitimate issue about the legitimacy of your marriage. I mean, if you are married, you should. If you cannot find your wife or your husband or your spouse, there's something wrong. If I'm an immigration officer, I will have a major concern with that kind of marriage. Why will you not be able to locate your spouse? That shows you are not living together. If you are living together and your spouse went out of the house, you will call the cops and file a missing person report. It means if you are saying you can't find your spouse, then something is wrong. So I have a legitimate concern about that relationship. So whether you go for interview or not go for interview is not even the issue, because you will just probably end up creating evidence of 204C marriage. That's what I will say here. I will not go further than that. I believe that you get the message. The next question. Oh, is it okay? This one is a two-part question. Part one: my employer petitioned for me. I was able to file the application for green card, and I've been renewing my work permit every year. Unfortunately, my employer died in a car accident. Part two: and I was called for an interview 3 months after his passing. What are my options? Well, based on this question, I'm assuming that this application has been pending for more than 3 months, more than 6 months, because if you have renewed employment authorization multiple times, that means that it has been pending for more than 6 months. Yeah, you can actually convert this to another employer. All you need to do is just to find a new employer who will be willing to employ you. That is all you need to do. And this petition will be alive and you will be able to get your green card. It is called AC21. You can change your employer if your application for adjustment has been pending for more than 180 days. So you can change. So just look for a new employer before you go for interview. So all the new employer need to do is just to give you a letter of employment. That is it. They don't even need to file any petition or do anything, just to offer you employment. That's it. And I don't even know if this is current because it said I was called for interview within 3 months after his passing. So has the interview been attended or is it something in the future? Because if you have already attended the interview, it may be too late if you didn't provide a new employer. But if the interview is in the future, just look for an employer who will be able to give you a letter of employment, and that is all you need. And you'll be able to get your green card. You'll be able to complete the process. Yeah, I'm waiting. Okay. The next question. I have a question, but it's not related to the topic. Please, may I ask? Well, send in your question. If it is something we can answer, I will definitely do. Go ahead and send in your question. Okay. The next question. My child was going to petition for me. However, he recently passed away. He was physically abusive to me. I hate to say this, but can I file VAWA against someone who has recently passed away? Well, number one, sorry for your loss. And number two, sorry that you are even in a situation where you have to discuss. If there is no issue of death of the petitioner, then the petition dies a natural death. The petition dies a natural death if the petitioner decides to withdraw. Okay, the next question. Am I waiting for something? Okay.
I'm having to do it on the phone now, and it takes longer for me to type.
Do you have questions from your end?
I'm sending it. I transferred it.
Oh, okay.
I'm sending it.
Okay, the next question. Where do I stand if my employer is telling me they want to withdraw the I-140 petition? My green card application was filed concurrently. Well, this question does not have a lot of facts. Is the I-140 still pending? Has it been pending for more than 180 days? I don't have enough information to properly answer this question, but I'm going to answer it based on assumptions. Number one, if the since it was filed concurrently, if the I-485 has been pending for more than 180 days, the applicant can change employment. He can change employer. However, the employer will have to submit a new I-140 petition, and the job duties must be exactly the same. So, but if the I-140 has already been approved, then the employer will not need to submit a new I-140 petition. The green card application can be based on the approved I-140 petition. But if the I-140 petition is still pending, then the applicant can change employer, but the new employer will have to file a new I-140 petition and take over the adjustment application from that end. Now, this question that is not relevant to today's topic, let me just see if I can answer it. The priority date of my I-360 is July 2020. I have filed for green card since February 2022. And May Bulletin have the cutoff date as November 2020. for certain religious worker. Where's the question?
It's below the next one.
Okay. I've been thinking that since priority date from the bulletin of April and May 2024 captures my time period, I should have received my green card by now. It's really tiring waiting for this. I still don't see questions here. What's the question? Well, green card being approved and visa bulletin being current, they are not the same thing. They are not the same thing. Visa bulletin, what that means is that if visa is not current, they cannot even approve your green card. It is not statutorily possible. They have to wait until visa becomes current before they can approve your green card. Now, because visa is current and green card being approved, they are two separate things, because for a green card to be approved, all the requirements of green card must still be met. They will still have to do a background check. They will still have to confirm that you are not related to terrorist organization. You do not have any other thing. They will still have to confirm that you do not have any criminal record. They will still have to confirm that the I-360 was not a fake employment. There's a bona fide offer of employment, and now look at your application. But they still have to look at the application and realize that it is approvable. Even they have to check that your medical is still current, is not expired. So there are so many factors, because the fact that a visa is current does not mean a green card can be. It means, but because visa is already current in your case, I can advise you can do a service request. So that can trigger something if you. Huh? Yeah, so you can do a service request because visa is current. And if you also meet the requirement of expedited processing, because your visa is current, you can request expedited processing of the I-485. But like I said, you still have to meet all the requirements of green card before they can approve it. Before that,
Yeah. Start.
it says part 2.
Go above that. Go 2 above that.
Okay.
I recently found out.
Okay, yeah, I saw it. Thank you. Okay, the next question. I recently found out that my ex-wife wrote in to withdraw support on I-751. I was never informed, but the case was denied. I actually wrote in to convert the self-petition, but never heard back. Okay, part 2. Never heard back from USCIS. Apparently, the case was denied before I tried to convert it. I only found out at my N400 interview. I honestly never knew the case was denied. What can I do? Well, just refile the I-751 and file it as a self-petition based on good faith marriage, and then attach all the evidence of good faith marriage to the application. And then if after you file it and you have your receipt and probably biometrics, if you are already eligible for citizenship, you can apply for citizenship so that will force the expedited processing of the 751. The next question. These things are not numbered, so I'm just trying to be sure I don't jump any other one.
What if my petitioner renounces citizenship?
Okay. The next question. What if my petitioner renounces citizenship? Does mine get renounced too? Well, this question is not that very clear. When you say mine get renounced, does it mean that Is this person already a citizen? Is this person a permanent resident? What are we talking? That is petition announced. It is individually based. Even if you are not a citizen yet, if you have a green card, you can still apply for your green card. If you are already a citizen, the fact that your petitioner renounced his own citizenship does not mean your own is renounced. No, it is an individual thing. So your citizenship is still valid. It doesn't affect it at all. The next question, I think this one is a two-part question as well. Part one, what should I do if I no longer wish to sponsor my husband for immigration? We married abroad and have no official record of marriage here in the state. Do I still need to file for divorce? Oh yes, if you are married, it is always better to do things right. If you are married abroad, go ahead and file for divorce. You don't necessarily need to file the divorce over there. You can file the divorce here if you live here. Because if you file the divorce abroad, that divorce may be questionable because of your residence. So in most jurisdictions, you are required to be a resident of the state or the country where you are filing for divorce. So if you live in America, it is better to file the divorce here. It doesn't matter whether your spouse is, for example, if it is a customary marriage can be terminated without going to court. So all you need may be to swear to an affidavit and take it to the customary court and register it. Then that is it. And of course, if your family received dowry from the other side, you return the dowry, and that's it. You are divorced. But it's better to comply with the process, because if you don't, your husband can submit something in the future that will raise question about your own eligibility to remarry here in the US. So it's better to just do it right. Once you are married, make sure you terminate that marriage. But if you are from Nigeria and if your marriage is customary, it can be terminated without going through divorce process in court. Okay, the next question. Oh, is this a part two? I wouldn't like to continue with my process because I will feel guilty, but just to know, could I continue?
Yeah, that's part two. Go up.
Sponsoring him and leaving, right?
That was
So
also.
the next one for you will be my wife and I had a joint.
Oh, okay. I was actually reading a different question. Thank you for pointing my attention to it. Okay, the next question. My wife and I had a joint 751 pending, but she just passed away, car accident. Can I convert to self-petition even if the petitioner died? Oh yes, you can convert to self-petition. You just need to write them a letter, attach a copy of the death certificate, and tell them that you still want to continue with your petition based on good faith marriage. Yeah, you can convert it. The next question, I think this is another two-part question. I think it's this two-part question that causes confusion. Yeah, this is another two-part question. My son was in the military. I got parole in place, granted, and I was about to file for green card, but my son passed away just 1 month ago. Of course, I'm so heartbroken right now. Okay, part two. I wouldn't like to continue with my process because I will feel guilty. But just to know, could I continue with the filing? Yes, this person can continue with the filing. There's nothing to feel guilty about. I mean, he's dead. You didn't kill him. So that's not something That's not something to be, guilty about. You don't have to feel guilty. I mean, things happen. So I don't think there's any issue with that. You can continue. The next question. As a U.S. citizen and petitioner of a spouse immigration, can I relocate outside of the U.S. until my spouse case is approved? I will need more information to answer this because I don't know if what is pending is just the I-130, whether there is already a kickstart of the consular process, whether this person is in the embassy stage and all of that. But the truth of the matter is that based on this fact, definitely the beneficiary is not in the US. And because the beneficiary is not in the US, that means this process is going to be consular processing. And because it is consular processing, the final stage of a consular process application or petition is the US Embassy. Usually, when the applicant appear for interview, they will want to see evidence that the petitioner was actually living in the US. And sometimes the embassy may ask for proof. And of course, they can also verify it because as a US citizen, if you travel out of the US, they will know. Remember, US embassies, they are under the Department passport. So from the petitioner's passport, they can actually know that the petitioner is not living in the US. But for you to bring somebody to the US, you have to be living in the US. So even if it's approved to get the immigrant visa approved, however, there are a few exceptions. So it depends on what the petitioner is doing abroad. If the petitioner is abroad in the military, it will not affect it. If the petitioner is abroad and is working for an American company abroad, it will not affect it. If the petitioner is abroad and is working for an American company, for a company abroad, and that company is, the shares of that company, at least 51% of the shares of that company is owned by another American company, it will not affect it. If that petitioner is abroad and is working for a U.S. for a non-profit organization abroad, again, it will not affect it. So those are the exceptions to it. Otherwise, the petitioner will need to return to the U.S. in order to get it approved. The next question. Good afternoon, sir. I was working for a company that petitioned for me. The company just filed for bankruptcy. Can they continue being my petitioner even though they filed bankruptcy? Well, I don't know the stage this process is. If you have already filed I-485 and the I-485 has been pending for at least 180 days, this is the time to look for another employer. Again, if your I-140 has already been approved, the new employer will not need to refile anything. All they will need to do is just to give you a letter of employment and you will still be able to get your green card. But if the I-140 is yet to be approved, then the new employer will need to refile your I-140. So that is the way this works. But they may still be able to use the labor certification that was used on your behalf by the employer that filed for bankruptcy. But don't wait until the bankruptcy is over because it may be too late. But you may take your chances. If the I-485 is approved before the end of the bankruptcy, you will still be okay. But if it is not approved before the bankruptcy is over, your application may be denied. So that is why it is better to get another employment right now. But if your I-140 has been approved, the new employer does not need to refile the I-140. All they need to do is just to give you letter of employment. But if the I-140 has not been approved, the new employer can and is not working in the USA for 8 years, can he petition his foreign wife to come to the US? Well, like I said, this is not a yes or no question. So it is not a yes or no answer. So it depends on a lot of factors. It depends on what the husband is doing overseas. It depends on who the husband is working for overseas. Like as I said previously, if the husband is working for a US non-profit overseas, yes, he can still file the petition. If the husband is working for a US company overseas in management position, yes, he can still file the petition. If the husband is working for an overseas company that is owned by an American company, at least the American company owns 51% of his shares, yes, he can still file the petition. If the husband is in the US military, yes, he can still file the petition. But if the husband does not meet any of these conditions, the husband will be required to come back to the US in order to bring the wife to the US. You cannot bring someone to the US if you are not here. So that's like sending somebody where you are not. When you petition for somebody, you are bringing that person to come and join you. So if you are not here, you can't bring somebody here except you qualify for any of those exceptions that I just listed. The next question. Good afternoon, sir. My I-485 under the religious category was returned based on backlog. Do I need to fill a new form entirely as well as new medicals if my priority date becomes current? Well, it depends on a number of factors, but based on what I know, the answer will be yes, because on April 1st, virtually every single application in the immigration process were updated. So whenever your visa becomes current, you may need to file a new complete a new application because you probably completed the old application. And as for the medical, it depends on whether your medical is expired or current at the time your priority date becomes current. So you may have to fill a new petition because all the immigration forms were updated on April 1st of 2024. The next question. I was here as a visitor and met my husband. We fell in love and got married. He petitioned for me and my case is still pending. My husband disappeared as I filed for a missing person report. Part 2. Since you filed a missing person report, you go for the interview and show them a copy of the report. Because if he disappear into thin air, he may still be alive and he may also be dead. But they cannot convert the petition to a widow or widower petition until there is evidence that he is dead. So I don't know if you have a lawyer or not, but what you can do is to request that your application be placed in abeyance, at least until you find out what happened to him. And you can show the police report as evidence of his missing. So I don't think they will I don't believe they should deny your application on that ground. Am I expecting any other question? Okay, that seems to be the last question we have so far. If there is any other question before I round up, I will definitely answer it. But for now, the topic for today is what do you do if can you please repost that topic? I don't even have it. Yeah, what do you do if your petitioner is no longer interested or able to pursue your case? And we have been answering different questions relating to that. In most cases, such petition will be salvaged, but it is not a one-cap-fits-all. Sometimes there are petitions that may be saved, and sometimes other petitions may not be saved. Sometimes there are petitions that can be converted to another kind of petition, but it is not every petition that is eligible for this. Sometimes the applicant can change employer if it's an employment-based petition, but again, it is not every applicant that is eligible, and it depends on where you are in the application process. So we believe that we've been able to answer a lot of questions on this today. So, and we realize that it's already 1 o'clock. So in the absence of any other questions, we'll probably, do we have a question before I close it for today?
It's not related to this. It's not related.
She's checking.
I do.
You can just read it out and I can
I
answer.
have one that was for last week's topic. Another one. Somebody sent one in.
Read the question. Hello, sir. I have a serious question about our K1 visa. My fiancé K1 was rejected by the counselor in Accra, Ghana, due to our engagement ring and our pastor and family. Is there any hope of continuing our case? Well, this is a complex situation because for K1 visa, K1 visas are non-discretionary. I've explained this over our podcast multiple times. There is a difference between immigrant visas and non-immigrant visas. K1 is a non-immigrant visa, and because of the element of discretion, there is no room for appeal. However, if you file I-130 petition, which is an immigrant petition, that cannot be denied by the embassy because that one is not a discretionary thing. If that one could only be returned to USCIS with a recommendation for the approved petition to be revoked, in which case the USCIS will give the petitioner an opportunity to respond to the issue raised at the embassy, and then they give the petitioner 30 days to respond, after which they will now take the final decision. But in the case of a K1, because K1 is a non-immigrant visa, there is no room for appeal, and the application may not be the application may not be returned to USCIS. It may just be denied by the embassy. So unfortunately, you are entirely at the discretion of the embassy. But what I would suggest, before you give up, as a US citizen, send an email, a detailed one, to the embassy explaining that this was just engagement. It wasn't a marriage. So explain it. Even though that should have been explained during the interview when they interview your fiancé, because most of the time what happens is that the interview, then after the person comes out and probably call you in the US, you are the one now telling them what to do or what to say. At that time, it may be too late. So the person who attended the interview, your fiancé, should have insisted and asserted during the interview that no, we were not married. This was my engagement ring. So that should have been done during the interview. But again, because the K1 is a non-immigrant visa, there is no room for appeal. So if they deny it, your only option, if you try sending them an email and listening to their response, if their response is sorry, this is denied, then your option would be to travel back home, get married, and then come back and file I-130 petition on behalf of your fiancé. I don't think I have any other question. Okay, so in the absence of any other question, here is where we are rounding up for today. As I always say, this podcast is every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. And currently, that is 6 p.m. Nigerian time, and it is 10 a.m. Mountain time. So I encourage you to invite your friends, family, colleagues, and join us. Spread the news. I mean, we are doing this free of charge. We are not charging anything for it. And of what purpose will it serve if you receive all this information and you don't pass it to others? If we are hiding the information, you will not get it. So if you are able to get it for free, why not allow others to get it also? Like I've always said during this podcast, I'm not doing this for money. It is for legacy. It is to prevent people from making avoidable mistakes. So the only thing you can do to show appreciation is to let others too benefit from the wealth of information that we provide here on weekly basis. For now, I will say goodbye. Hope to see you again next week. God bless you. Remember to join us on our social media. Follow us on Instagram. We also have Reel, where we provide daily useful information, short clips of very, very useful information. So just follow us on Instagram, follow us on TikTok, follow us on Facebook, and remember to join us next week, Wednesday. God bless you. This is Dr. Olu Asekun.